It's a big bill. Ms. Bailey, can you just record for the minutes the apologies that we have for absence, please?
Certainly, Chairman. Senator Aubin Hill, Senator Donald Webby, Minister Favour Williams, Member Robinson, and Member Graham will be absent. And Senator Johnson Smith indicated that she'll be late.
Okay. All right, the minutes of the last meeting were circulated and are before us. Are there any suggested corrections to the minutes? And that's the minutes of the meeting of July 8th. If there are no corrections, may we have a motion to adopt the minutes?
So move. So move, Chairman.
Thank you, Member Hilton. Seconded by.
Seconded.
Thank you very much, Member Mallory-Fort. And without any further ado, well, matters arising from the minutes, Ms. Bailey, for today.
Chairman,
Anything for
to
today?
just resume the clause by clause.
Okay, without any further ado, we
No,
will.
there was a matter, Chairman, there was a matter at page 5 that for which we had said the members said they wanted to get a sense as to what the best practice was in respect of search and respect of search.
Yes, we did. So that goes on the list of probably 15 things now that we're going to circle back to at the end, once we've gone through the clauses, or through the, once we've finished the review of the clauses and schedule.
Fair enough. Just that it said that they'll report this week. But
yes, okay. Understood. Okay, beginning clause by clause with at clause 253, I believe. And is that you, Ms. Edwards?
Crystal Corbett.
Okay. Over to you.
Very well. Part 14, offenses. Clause 253, specified offenses, third schedule. Subclause 1. For the purposes of this act, the offenses set out in the first column of the third schedule are the specified offenses, and the penalties specified in the second column of that schedule shall apply respectively to the offenses upon summary conviction before, unless otherwise provided, a judge of a parish court. 2. In the case of a conviction for an offense under section 40, subsection 5, before a parish court, the court shall, if no request is made to it under section 52 of the Proceeds of Crime Act, refer the matter to the Director of Public Prosecutions, along with the notes of evidence and the court's observations thereon, for the purpose of considering whether an application ought to be made under section 52 of the Proceeds of Crime Act. 3. The minister may, by order, subject to affirmative resolution, amend the third schedule. Clause 254, administrative penalties, fourth schedule. Subclause 1. For the purposes of this act, the applicable offenses are the offenses set out in the fourth schedule, and any other offense to which an administrative penalty may be applied by virtue of any provision made by or under this act. 2. Where the commissioner has reasonable grounds to suspect that a person has committed an applicable offense, the commissioner shall, in respect of the alleged offense, A, issue an informal warning to the person, B, issue a formal warning to the person, or C, issue an administrative penalty notice to the person. 3. For the purposes of subsection 2, A, an informal warning is a notice of the contravention given without any particular requirement as to form, a record of which is maintained in accordance with rules, but which, 1, shall not be taken into account in assessing a person's compliance with customs laws. 2, shall be taken into account in determining whether a formal warning or administrative penalty is issued in respect of any further contravention. B, a formal warning is a written notice of the contravention in the form prescribed by rules, a record of which is maintained by the Commissioner in accordance with rules for the purpose of 1, assessing the person's compliance with customs laws, and 2, determining whether an administrative penalty notice is issued in respect of any further contravention. 4, an administrative penalty notice under this section is a notice in writing in prescribed form, offering the person to whom it is issued the opportunity to discharge any liability to conviction of an applicable offense by payment of an administrative penalty under this section. And the notice shall, A, give such particulars of the offense alleged as are necessary for giving reasonable information of the allegation, and B, state 1, the period, whether 15 days or a longer period, during which, by virtue of subsection 6, proceedings will not be taken for the offense, and 2, the amount of the administrative penalty payable by the person. 5, where a person is issued an administrative penalty notice under this section, proceedings shall not be taken against any person in respect of the applicable offense concerned until the end of 15 days following the date of the notice, or such longer period as may be specified in the notice. 6, a person to whom an administrative penalty notice is issued under this section shall not be liable to be convicted of the applicable offense concerned. A, if the person pays the administrative penalty with respect thereto in accordance with this section, and B, if the offense is a continuing offense, the person has taken steps such that the offense no longer continues before the later of expiration of 15 days following the date of the administrative penalty notice referred to in subsection 4, or such longer period as may be specified in the notice, or the date on which proceedings are begun in respect of the offense. 7, in subsections 5 and 6, proceedings means criminal proceedings in respect of the act or omission constituting the offense concerned, and convicted shall be construed accordingly. 8, payment of an administrative penalty under this section shall be made to the Commissioner, and in any proceedings, a certificate that payment of the administrative penalty was or was not made to the Commissioner by a date specified in the certificate shall, if the certificate purports to be signed by the Commissioner, be admissible as evidence of the facts stated therein. 9, in any proceedings for an applicable offense, no reference shall be made to the giving of any notice under this section, or to the payment or non-payment of an administrative penalty under this section, unless in the course of the proceedings, or in some document which is before the court in connection with the proceedings, reference is made by or on behalf of the accused to the giving of such a notice, or, as the case may be, to such payment or non-payment. 10, the conduct specified in column 1 of the 4th schedule constitutes offenses for which A, the penalty on conviction specified in column 2 of that schedule shall apply as the maximum penalty that may be imposed in relation to the respective offense upon conviction before a judge of a parish court. And B, the administrative penalty specified in regulations made under subsection 11 shall apply in lieu of the respective offense in accordance with the provisions of this section. 11, the minister may, subject to affirmative resolution, make regulations providing for any matter necessary for or incidental to the operation of this section, and in particular, such regulations may A, prescribe 1, the form of the notice to be issued under subsection 2C, 2, the nature of any information to be furnished to the commissioner, along with any payment of an administrative penalty. 3, provisions for the cancellation or variation of notices issued under subsection 2C. B, amend the 4th schedule. And C, specify the administrative penalty that applies in lieu of conviction for the offense, and for that purpose may specify different levels of administrative penalty in respect of specified circumstances relating to the commission of the offense, for example, having regard to the gravity of the contravention, the value of the goods concerned, whether loss or damage is caused to any person, or the mens rea involved in the commission of the offense. 12, the commissioner shall not maintain.
Sorry, just before we go on, Chairman, through you, Madam CPC,
Yeah, go ahead, please.
could we just rearrange where the subject to affirmative resolution is put, and that it's put after making regulations? It's kind of, I mean, just a technical point. So the minister may make regulations subject to affirmative resolution instead of the minister may, subject to affirmative resolution, make the regs. Madam CPC?
Yes, AG, hearing you, I was just considering.
Right, okay. Yes, thanks.
Yes, all right.
Thank you, yes. Thank you, Chairman.
No problem. Please continue.
Commissioner shall not maintain a record of any administrative penalty imposed under this section longer than 7 years after the date of the
Ms. Corbett, something has gone wrong with your internet connection all of a sudden.
Yes, I was wondering, yes.
The line, try again, talk again.
Well, the commissioner shall not maintain a record.
It deteriorated just all of a sudden.
Are you hearing me now?
No, it's still bad. You want to log out and log back in? Not log out. Dial where you disconnect and reconnect.
Can you indicate whether or not you're hearing me clearly now?
No, it's not hearing you at all. There's something, it's gone. Ms. Edwards, you can take over until we figure that out, or someone. Sorry about that.
Yes, I will. I'll just
Ms.
ask Ms.
you want
Corbett
to, can you,
continue
yeah,
to-
can you just leave the call and then come back in and see if it's any better, and then we can transition from Ms. Edwards back to you. Hi, you heard what I said? What I'm suggesting? Yeah, just leave and dial back, or not dial back. What is it these days? It's
Reconnect.
okay, great. All right, Ms. Edwards, you let's see if we can continue, and then if she can dial back and it's easier to hear, then we can go back to her.
Just give me 1 minute, Minister. I'm about to just project to share my screen. Which is taking some time. We have been having some difficulties with our internet.
Minister, in the meantime, just for the benefit of those who are listening, they will observe that this part of the bill is doing something in a new way formally, where any suspicion of breach of the law, the person is provided with a very transparent scheme to make good on any breach of the law. And it is an escalating system, so that it moves from one level to the next. And it specifies where records are kept in respect of your history of compliance and where they are not kept. And it is certainly the forward direction in which to go in helping persons to understand where they stand in respect of compliance of the law and how their interaction with the law and the system will be regarded.
No, thank you. Thanks for that editorial, AG. It's always helpful to, contextualize what is being, what we are actually approving. All right, you ready?
Yes, I am. Ms. Corbett still seems to be.
Having difficulty. You just go.
I
All right.
am back.
Oh, you're back. We can hear you.
If it is that
Okay.
you can hear me clearly, are we still at 12?
Yes, we have
Yes.
removed.
Very well.
So you want to go?
I will.
All right, wonderful.
The commissioner shall not maintain a record of any administrative penalty imposed under this section longer than 7 years after the date on which the administrative penalty notice in respect thereof was issued. 13, notwithstanding subsection 12, data relating to administrative penalties may be kept by the commissioner if that data consists of statistical information that does not reveal the identity of or any other personal information relating to any person to whom an administrative penalty notice is issued. 14.
And Chairman, if I just may, again, for the benefit of the listening public, these provisions are also filtered through a rights perspective to enable the keeping of record to a certain period, and that period is of significance for tax purposes, and thereafter it's really for research and data gathering purpose, but the data would be anonymized after that point.
Understood.
14, information relating to administrative penalty notices may only be published by the commissioner if it is statistical information as described in subsection 13. Clause 255, legal proceedings. Subclause 1. Where a person charged with an offense under customs law has absconded, that person may be tried, convicted, and sentenced in that person's absence. 2. An officer shall be deemed to be a competent witness at the trial of any matter relating to the enforcement of a customs law, notwithstanding that the officer may be entitled to a reward upon the conviction of the party charged in the matter.
Recording in
And
progress.
Because it talks about certificate purporting to be signed. by-
That being the case, once it's a
Appropriate.
purporting, it would be
Right.
prima facie.
Yes.
All right, thank you. So just insert it there, Madam CPC. Thank you so much. Thanks, Chairman.
Thank you, AG. Thank you, CPC.
Yes.
Okay. Clause 256. Subclause 1. Notwithstanding anything contained in any other law, where a court imposes a monetary penalty for an offense under this act, and the penalty is not paid, the court may order that in lieu of payment of that penalty, the offender be imprisoned for a term not exceeding A, 1 year, and in any case where the monetary penalty concerned is $1 million or less, B, 5 years, in any case where the monetary penalty concerned exceeds $1 million. 2, where in respect of any offense under this act, it is established that A, while engaged in the commission of the offense, the offender, 1, used force or the threat of harm to any person or property, or 2, was disguised in any way to conceal the offender's identity, or B, there are any other circumstances which the court considers to have aggravated the offense, the offender shall, in lieu of the penalty that would otherwise be applicable to the offense, be liable on conviction to a penalty not exceeding 3 times the amount of that otherwise applicable penalty. 3, where a person is convicted of an offense under this act, the court may, in addition to any penalty imposed under this act, order the person convicted to pay a fixed sum as compensation to any person who has suffered loss as a result of the commission of the offense. 4, an order under subsection 3 shall be without prejudice to any other remedy which the person who has suffered loss may have under any other law. 5, the court may make an order under subsection 3 of its own motion or upon the application of any person in accordance with subsection 6. 6, the person who has suffered loss as a result of the commission of the offense under this part may apply in accordance with rules of court for an order under subsection 3 at any time before sentence is passed on the person against whom the order is sought. Clause 257, place where offense may be tried. Notwithstanding anything contained in any other law, in any case where a question arises as to where in Jamaica an offense under customs law is committed, the person alleged to have committed the offense may be tried before the parish court having jurisdiction in the place where the person is A, arrested for the offense, or B, landed if arrested off land.
May I just ask for clarity, a provision like this, in effect, extends the jurisdiction of the parish court to try the matter, regardless of the sum that is alleged to be involved. And that is what we are doing. And it also takes care of technical rule in terms of parochial jurisdiction, which of the parish courts would have the jurisdiction to try the matter.
Thank you, AG.
Clause 258, value of goods and determination of penalty. 1, where the amount of the penalty applicable in respect of the contravention of a customs law is to be calculated based on the value of goods concerned, the value shall be determined in accordance with section 20. 2, a certificate signed by the commissioner as to the value of goods determined in accordance with subsection 1 and the import duty and tax applicable thereon shall be accepted by a court as prima facie evidence of the value of those goods and the import duty and tax payable thereon. Part 15, General. Clause 259. The Commissioner may exercise any of the powers given to the Commissioner under this Act in the contiguous zone as defined by Section 2 of the Maritime Area under this Act. 2, without prejudice to the generality of subsection 1, regulations made under this section may provide for A, the charging and recovery of fees in respect of any matter under this Act. B, the manner in which and the person to whom fees and other charges under this Act are to be paid. C, the remission, refund, or waiver of, or the exemption from fees or other charges, not including duty and tax payable under this Act. D, the rate of interest to be paid in respect of an overdue debt for the purposes of Section 8, and the circumstances and manner in which such interest shall be paid. E, the licensing of customs brokers. Clause 261, rules. Subclause 1. Subject to Section 262, subsection 2, the Commissioner may make rules in respect of any matter required to be determined, directed, or prescribed by rules under this Act, and without prejudice to the generality of the foregoing, such rules may make provision in respect of A, the communication systems administered by the Commissioner for the implementation of the customs laws, including the conditions and requirements for electronic transactions with the Commissioner. B, the form and contents of any report, notice, document, or other information required to be submitted to the Commissioner or an officer under this Act, and the manner of such submission. C, the circumstances and manner in which, and the conditions on which any report, notice, or other document referred to in paragraph B may be amended. D, subject to the provisions of this Act, the records that persons to whom this Act applies shall keep for the purposes of this Act, and the manner in which, period for which, and place at which those records shall be kept. E, the form of any notice required to be issued by the Commissioner under this Act. F, the days and hours during which the services of the Customs Agency shall be provided to the public, and the working hours of officers for the purposes of doing anything required under the customs laws. G, the provision of statements of accounts of the application of the proceeds of the sale of goods under Section 122. H, issued by the Commissioner of non-binding advice on any matter. I, subject to the provisions of all applicable laws, the procedure for the conduct of searches of premises, places, persons, or things under this Act, and different procedures may be specified for different types of searches. J, the effective administration and control of government warehouses. And K, the conduct of activities in customs controlled areas, including with respect to the security of such areas. 2, rules made under subsection 1 shall be published in the Gazette and shall come into operation upon the expiration of 14 days from the date of such publication. 3, no rule made under this section shall be construed to have retroactive effect. Clause 262, publications. 1, the Commissioner shall, on the public website of the Customs Agency, and in such other manner as the Commissioner...
Sorry, Chairman. Sorry, I just had a little technical glitch here. Just from a public and administrative law perspective, there are some things that become clearer to us and to me as Attorney General. And I would ask that in respect of this clause 261, that the making of the rules, the power that is being given to the Commissioner in respect of the making of the rules, be made subject to the general policy direction of the Minister. I can go into the explanation, which will be long and detailed, but it's really just to ensure that you have, what's the word I'm looking for? Unity and oneness, as it were, in respect of the general policy direction on these very important revenue matters. So would ask for a consideration to be given to inserting at some point in the chapeau of 261(1), we're making the rules in accordance with or subject to the general policy guidance or policy direction of the Minister, something to that effect, Chairman.
No, that's a,
If the reason is not readily clear, I would just say that because the revenue matters, border security matters, and all things for which the customs would have responsibility, at all times you want to ensure compliance. It may or may not happen, but just out of an abundance of caution, just to ensure that the making of those rules is within that context.
that's a good point, AG.
Thank you.
And since this was first, yes, we first started the drafting of this many, many years ago. I think we've, I get what you're saying. How, do you have the words? Do you have suggested words?
In the court. Some issues arise in the court where we have just had to look back and analyze and realize that, you know, a few words added to the provision where power is given to do certain things would make a difference. Yes.
Do you have suggested words, or you want to just note it?
The wording we would use here would be with the approval of the minister, where we have
PP. Those are the words I was looking for.
Where would you put them? Where would you put them?
The commissioner may, with the approval of the minister, make rules.
Yes.
Thank you, CPC. Those are the appropriate words. Yes.
All right, thanks, CPC. Thank you, AG, for raising that.
Clause 262.
I would say generally, Minister, sorry to delay, that the principle, the policy and principle would apply in respect to all of the rules making provision.
I can see it's a general thing that should.
Given to the
Agreed,
committee.
agreed, absolutely agreed.
We can determine how to fix that up. Yes.
Yes.
Clause 262, subclause 1. The commissioner shall, on the public website of the Customs Agency, and in such other manner as the commissioner considers appropriate and expedient, publish or otherwise make freely available the customs laws, such administrative guidance, and other information as the commissioner considers relevant for publication in respect of the customs laws, and all information as to the applicable fees and forms required under this Act. 2. Before any regulations or rules under this Act are brought into operation, the person responsible for making those regulations or rules, as the case may be, shall cause them to be brought to the attention of the public by publishing them on the public website of the Customs Agency, together with a notification inviting the public to submit comments on those regulations or rules within a specified period, not being less than 21 days before the regulations or rules, as the case may be, are brought into operation. 3. The person responsible for making the regulations or rules shall revise the regulations or rules, as the case may be, as that person considers appropriate, having regard to the comments submitted under subsection 2 before the regulations or rules are brought into operation. 4. Subsections 2 and 3 shall not apply to any provisions relating to national security or which are necessary in the public interest or in the event of any public emergency. So, however, that such provision shall be subject to negative resolution.
May I just ask that we add public emergency or public disaster?
So it would read,
right, in the interest, in public interest, or in the event of any public emergency or public disaster.
okay.
Because we do have the public emergency as defined under the Constitution and the public disaster under the Disaster Risk Management Act.
Okay. Thank you.
Chairman?
Please go ahead.
Right, I wanted to raise the issue relating to this clause 262. When we were looking at clauses 27 and 29, the CPC, which deals with the power of the minister to appoint customs controlled ports or customs controlled airports by means of notice published in the Gazette or by order published in the Gazette. I recall that on that occasion, the CPC had indicated that clause 262 would have an impact on those provisions, in that notices and orders would of course be regulations under the Act, and they would therefore be subject to the publication requirements. And so the CPC had at that time asked us to consider whether that would have been our intention. And certainly on review, we want to bring it to your attention and to the committee's attention that to our mind, it would not be appropriate, it would seem on further review, for the publication requirement and the public commentary requirement to be applicable to all the subsidiary laws to be developed under the Customs Act. In particular, we have flagged the appointment, as I mentioned, of the customs control airports and the customs control ports, which would impact clauses 27 and 29. The question as to whether we would wish to have clauses 246 and 248, which deals with the power of the minister to declare certain goods to be prohibited goods or restricted goods, whether it's appropriate for that to be subject to the publication requirement. And importantly, most significantly, to consider excluding from the publication requirement clauses 3 and 4, which deals with the minister's power to impose or reduce duties and taxes by means of orders published in the Gazette, and in fact allowing the mechanisms outlined in the legislation to be the ones that apply without any question of there being a need for a publication requirement.
In addition to that, thank you, Hazel. I was actually going to ask for a rephrasing of subclause 3 of 262, so that, because as it is now, it means that in the revision of the rules and regs, the comments would have to be taken into, because of where the shall is, to just indicate that, you know, it's really that in revising them, you may have regard to the comments that are submitted, and not necessarily that you would be bound, because you don't know the extent of the comments and what kind of comments that would be made. So 2 says, before any reg or rule under the Act are brought into operation, the person responsible for making those, and that would include the minister too, because shall cause them to be brought to the attention of the public by publicizing them on the public website of customs agency. Now, this first part of it is, again, you know, there is a three prongs to the rule of law, is that your rules must be publicly promulgated, they must be equally enforced, and they must be impartially adjudicated on. And moving in the direction of transparency, having regard to the complexity of the customs operation. My recollection of the discussion is that there would be all the rules under which the agency will operate would be reduced in writing, and persons would know upfront what they're dealing with. So they do not approach expecting to be judged under one set of standard, and then when it passes the counter, it's another set that applies across there. But I think the provision does need some rewording, and the point you've made has to be considered, because when you don't know the extent of comments that will be made, and the persons can make comments that they don't wish to be bound by it, or they don't, you know, the public element is large and varied. So we need a little reconsideration and rewording of this part, Chairman, to the CPC.
All right, so it sounds like the kind of rewording we might need, we won't be able to do on the spot.
Yes, I think we should just flag it and note it also for the minutes that we will come back to it. Tomorrow, your term, we would serve as one of the issues to be circled.
Right, but we're going to leave it with your office to propose, or is it CP? You will come with the proposal, or you want customs to come back with the proposal?
Chairman, may
Yes.
I comment here? I think this this section that we're dealing with is of critical importance. I think it adds to the transparency, and I think and the acceptance of these proposals, because the point has been made that previously I know persons have complained about procedures at the customs. I think this is an opportunity, and I think this is best practice and moving in an area and in a direction that will give the public, provide for the comments, give the public the confidence that those comments will be taken into account, and hence the comment period that has been provided for. Now, it may be, as the AG suggests, it may be that some tweaking may be necessary. First of all, this is just the general provision. The rules and the regs have now to come. But I think what I'd like to see in this, as it were, the empowering section of the Act, is that the provision for the comment be kept, that the period for comment be kept, and that the requirement that it be taken into consideration. Now, taken into consideration doesn't mean prior the acceptance of what is presented, but I think there should be some evidence that are some ways and means by which these fair comments or these comments could be the basis of any changes in the rules to come, and that there be some evidence that, and it's not this is provided for in many other jurisdictions. So I think it's not something that we're wrestling with, that we have, for which we have no best practice. There are practices that are available, and it should be, and I think those should be followed. And what we're seeking here is transparency and an engagement with this, particularly the stakeholder groupings.
If I may just add
Yes,
further.
please, AJ, go ahead.
Right. So what Member Hilton is saying is not at odds with what we've said. And the comment was not really to change the policy behind
Right.
the provision, because that is the direction in which we're going. It's just a tweaking of the language to ensure we don't have unintended consequences. And then for what Ms. Edwards had raised, for that also to be opined upon. But yes.
Okay.
At this stage, Chairman, I just ask that we flag 262 and the related provisions for reconsideration, and we can move on with the review of the other clauses.
Okay, I agree. Let's move on.
Clause 263. Records of customs business. Subclause 1. Unless exempted by rules, every person who conducts business as a declarant, an importer, exporter, customs broker, carrier, cargo aggregator, operator of a customs controlled area, warehouse keeper, airport manager, port manager, person concerned with the coasting trade, agent, or other person who conducts business under any customs law shall keep or cause to be kept in Jamaica in such form and manner as may be prescribed by rules all documents relating to the transaction of that business for a period of 7 years from the date of the particular transaction, and make them available as required under subsection 2. A person to whom subsection 1 applies shall, within 30 days after being required to do so by the Commissioner, or such longer period as the Commissioner may allow, A, make available to the Commissioner documents that the person is required to keep under that subsection, and any copies of such documents that the Commissioner may require. B, answer any question relevant to any matter arising under this Act in respect of those documents. And C, provide such facilities and assistance as an officer may require for the examination of the documents. 3, a person who contravenes subsection 1 or 2 or 2A commits an offense. 4, a person who contravenes subsection 2C commits an offense. Clause 264, production of documents. Subclause 1. The Commissioner may, by notice in writing, require a person
Just a moment, Chair.
Yes, go ahead.
There is a note in the chat that there are some stakeholder comments regarding clause 263. So Ms. Edwards, if you allow Chair her to look into that. I think the note is from Mr. Jeffrey Foreman.
Go ahead. Okay, I'm seeing stakeholder comments on clause 263. Oh, thank you for that. I missed that. Hazel, you want to take us through what those are, please? I can get it in a second here.
After your indulgence, Minister, I just need a moment to identify the comments.
Yes, myself as well. I guess the question was from one of the airport operators. The clarification is required about the type of records that need to be kept, and the definition of airport manager is unclear. And I think your response was that the details of the type of records to be kept will be in the regulations, and reference to airport managers to be removed, and the obligation to rest on the operator of the customs control area.
Yes, thank you, Chairman. That is indeed correct.
Yeah. All right, so we're going to make that change to airport manager.
Yes, to be
Remove
deleted.
airport manager and have the obligation
And
rest on the operator of the customs control area.
yes, and we would also be deleting the word. So we'll be deleting airport manager as well as port manager.
So that's port manager.
So those two words, those two terms will be deleted.
Thank you, Mr. Foreman.
Clause 264,
Mm-hmm.
production of documents. So clause 1, the Commissioner may, by notice in writing, require a person to whom section 263(1) applies to produce for inspection by an officer any documents that the Commissioner considers relevant or necessary for the purposes of an investigation or audit under this Act. 2, a person required to produce a document under subsection 1 shall do so within 30 days after receipt of the notice, or such longer period as the Commissioner may allow. And if the person fails to do so, the person commits an offense. 3, it shall be a defense to any proceedings for non-compliance with subsection 2 for the person to show that the person had a lawful excuse for not producing the document. Clause 265, manner in which documents are to be kept. Subclause 1, rules may prescribe the form and manner in which any documents required to be kept under this Act shall be kept. 2, If a document required to be kept under this act is stored electronically, the person required to keep the document shall, at the request of an officer, cause the document to be made available to the officer in a form that A, is legible and intelligible without the need for any password, key, code, or other method of deciphering it, and B, can be taken away by the officer. And if the person fails to do so, the person commits an offense. 3, where the commissioner requires an original document to be produced in respect of any imported or exported goods, the commissioner may A, require the document to be submitted in duplicate and retain the duplicate, or B, retain the original if the document is not submitted in duplicate. Clause 266, retention of documents by the commissioner. Clause 1, the commissioner may take possession of and retain any documents required to be produced under this act. 2, if the commissioner takes possession of a document pursuant to subsection 1 or section 265(3)(b, the commissioner shall provide the person from whom possession was taken with a copy thereof, certified under the seal of the commissioner as a true copy. 3, every copy certified under subsection 2 is admissible as evidence in all courts and tribunals and for all purposes as if it were the original. 4, where the commissioner retains a document obtained by the commissioner under this section or section 263 or 265, the commissioner shall issue to the person from whom the document was obtained a receipt for the document in such form as may be prescribed by rules.
Chairman, raising the question for clause 266 subclause 2 and proposing that the word seal be removed, either entirely, either just indicating that the provision may be certified by the commissioner as a true copy, or certified under the stamp of the commissioner rather than the commissioner's seal, because usually these documents are certified and stamped, not necessarily sealed, and that may pose some, I would say, administrative challenges in light of the fact that oftentimes, particularly when documents are taken consequent on an audit, we are often dealing with a high volume of documents.
Understood.
It would not be inconsistent based on what we have seen in other provisions, which, for example, the provision we just looked at, clause 255, subclause 3E, where there's reference there to certified true copies of official documents under the hand and seal or the stamp of certain persons.
Okay.
Clause 267, audit or examination of documents. Subclause 1, subject to any express provision to the contrary in this act, the proper officer may, at all reasonable times, enter any place where any document required to be kept under this act is located and audit or examine the document, either in relation to specific transactions or to assess the adequacy and integrity of the method by which the document is created or stored. 2, for the purposes of subsection 1, the officer, A, shall, subject to the provisions of this act governing the entry and search of places, have full and free access to all lands, buildings, and other places where any documents that the officer considers, 1, necessary or relevant for collecting any duty or tax due under any customs law, or for enabling the performance of the functions of the proper officer, or 2, likely to provide information required for the purpose of enforcing any customs law, is located, and B, may take extracts from or copies of any such documents. 3, a person in possession of any document referred to in this section who refuses to permit the officer to audit, examine, or take extracts or copies of the document commits an offense. Clause 268, method of conveying notices, directions, and other documents. Subclause 1, any notice, direction, or other document required to be given by the commissioner or an officer to any person under this act may be given by A, delivering it to the person by hand, B, sending it to the person by registered post, addressed to that person's address, place of address, as last supplied to the commissioner by the person, C, telefaxing it to the person at such telefax number as is supplied to the commissioner by the person, or D, transmitting it to the person electronically at such address as is supplied for that purpose to the commissioner by the person. 2, where a person is required or permitted to give any document to the commissioner, the document may be given to the commissioner by A, delivering it by hand, addressed to the commissioner at any customs office, B, sending it by post, addressed to the official business address of the commissioner, C, telefaxing it to the official number designated by the commissioner for the receipt of telefaxes, or D, transmitting the document electronically in the manner prescribed by rules. 3, subsections 1 and 2 do not apply to a document in any case where this act specifies a method of delivery for the document. Clause 269, form of documents. Subclause 1. Every document submitted to the commissioner for the purpose of any customs law shall be in such form as may be prescribed by rules. 2, where any document required for the purposes of any customs law contains any words that are not in the English language, the person required to provide the document shall, in accordance with rules, provide with the document a correct translation of those words into the English language. 3, where any declaration or other document, A, is required by any customs law to be signed in the presence of the commissioner or any particular officer, and B, is signed in the presence of a witness who is known to and approved by the commissioner as a witness for the purposes of this section, the declaration or other document, as the case may require, shall be as valid as if it had been signed in the presence of the commissioner or officer in whose presence it is required to be signed. 4, where the commissioner is satisfied that any document referred to in subsection 1A contains any error of fact not affecting the amount of any assessment of duty and tax, fees, or other charges payable under the customs laws, and B, the interest of the integrity or accuracy of the document or the proper implementation of the customs laws necessitates the correction of the error, the commissioner may at any time correct the error and at the commissioner's own instance or on the application of any person. 5, rules shall specify the witnesses known to and approved by the commissioner for the purposes of subsection 3B. Clause 270, appointment of agents. Subclause 1. This section applies to the appointment of agents by persons who conduct business under the customs laws. 2. Subject to the provisions of this section, any action required to be performed by a declarant or other person conducting a transaction with the commissioner under this act may be performed by an agent appointed in accordance with this section. 3. A person shall not act as an agent unless appointed in accordance with this section. 4. The appointment of the agent shall be evidenced in writing in the manner prescribed by rules. 5. A person shall not be eligible to be appointed as an agent under this section if the person is not ordinarily resident in Jamaica, except in such circumstances as are specified by rules. 6. Rules made for the purposes of this section may A, identify the categories of persons entitled to act as agents, B, specify the rights and responsibilities of agents, C, specify conditions under which the commissioner may decline to recognize or carry out transactions with an agent, and D, prescribe the form for the appointment of an agent. 7, when transacting business under this act, the agent shall first disclose to the commissioner the fact that he or she does so as an agent, and if required to do so by the commissioner, shall produce to the commissioner the form of appointment evidencing that person's appointment as agent in accordance with this section. 8, a person who fails to make a disclosure or who is unable to produce evidence of the appointment as required under subsection 7 shall be deemed to be acting on that person's own behalf and shall be personally liable in so acting. 9, subject to subsections 10 and 11, for the purposes of this section, an agent shall be jointly and severally liable with the principal in respect of the acts performed as agent on behalf of a person who is not resident in Jamaica. 10, a person who conducts a transaction with the commissioner as a customs broker on behalf of another person is not liable for the payment of the duty and tax, fees and charges in respect of the goods concerned if A, the customs broker did not aid or abet the failure to pay, B, took all steps to prevent the failure to pay, and C, upon becoming aware of the failure to pay, promptly notify the commissioner of the failure. 11, nothing in subsection 10 shall be construed as relieving a customs broker from liability in circumstances where A, the name and address of the person on whose behalf the customs broker purports to act is not disclosed on the goods declaration, or B, payment of duty and tax was deferred on the basis of a deferment granted to the customs broker.
Chairman, this is a provision that was the subject of quite a bit of comment from stakeholders. And with your permission, I will go through and highlight some of the comments. All right, in relation to this provision, as you know, there were general concerns by stakeholders, particularly the customs brokers and shipping agents, regarding the issue of liability and how it is handled under the Act. One of the concerns related to clause 270, subclause 6, and there the comment was made that the JCA should focus on its mandate and functions and omit this provision. In relation to subclause 7, which provides that where an agent is once doing business under the Act, the agent must disclose to the commissioner the fact that he or she does so as an agent, and if required to do so, should provide a form of the appointment indicating that the person was so appointed as an agent. One of the concerns raised here is that this requires the agent to disclose his status to the commissioner, and where there's no disclosure, the person shall be deemed to be acting on his own behalf and shall be personally liable in so doing. And that is because that is the effect of subclause 8. The comment was that it is therefore inferred that an agent who discloses his status would not be held liable as a declarant or importer or exporter. And of course, we would confirm that once an agent discloses that he is acting as agent, then prima facie the agent is not liable unless it can be shown that the agent failed to comply with his responsibilities as agent, and as are laid out later at, for example, subclauses 10 and 11. The stakeholder, however, requested that it should be clearly stated in the Act that an agent who discloses his status is not liable. So they wanted that. Whereas subclause 8 states that if the person fails to make the disclosure, then the consequence is that the person is liable. They are requesting that a provision states that be inserted to state very clearly that if the person discloses, then he is not liable. The concerns were also raised that the term agent is defined as including, as referring to any person acting on behalf of another. And of course, concerns were raised that the definition of importer and exporter are written to include the role of the agent. And therefore, there were concerns that there would be the possibility under these provisions for the agent to be held responsible for a wide range of offenses which are not within the control of the agent.
And what was your proposed response to those concerns?
Well, we had several proposed responses, Minister. Firstly, in relation to clause 276, we are suggesting an amendment, not the one that the stakeholders suggested, which is a deletion of it, but perhaps some tidying up of the provision. So for example, at A, where it now says, well, 6 rules made for the purposes of this section may A, identify the categories of persons entitled to act as agents. We're proposing that be adjusted to read, may identify different categories of agents. So it's not so much about persons entitled to act, but the different categories of agents that may exist. At B, it now specify the rights and responsibilities of agents. And it is suggested that some language be inserted there to clarify that we're talking about the rights, responsibilities, and liabilities of each category of agent.
Understood. So it's not of individual agents.
Not so much, not of the individuals.
Individual agents. Does anybody have a problem with that? What other things you would propose in response to those comments? That would take care of the comments on A and B, right? Yes.
At B,
yeah, no, it would. What about the comment on 277?
No, I crave your indulgence, Minister. I am having some internet connectivity difficulties.
This is one, it requires an agent to disclose his status to the commissioner, and where there's no disclosure, the person shall be deemed to be acting on that person's own behalf.
Yes,
and
this is really based on a concept of direct and indirect representation. So if you act indirectly, in which case you would disclose.
Right, so yeah. So the thing that they're worrying about doesn't exist as long as they disclose.
Yes, as long as they disclose, so that, for example, with whatever documentation persons will be required to provide to customs, they would have appropriate boxes for them to indicate a field for the principal, who would be the importer, and then a separate field for perhaps customs broker, shipping agent, or other agent, so that there can be, the principal is expressly identified on the documents, and the agent is also clearly identified.
Okay.
We are also proposing that a provision be inserted at 6 to indicate that these provisions should stipulate the types of customs transactions which each category of agent may carry out on behalf of another person. So you will find that not all categories of agents will be able to do all types of customs transactions, because there'll be varying requirements and perhaps prerequisites that a person may need to satisfy in order to be able to act as an agent or to carry out a particular type of customs transaction on behalf of another person.
Understood.
One of the primary concerns, and it's my responsibility to bring it to the committee's attention, that the agents had raised, had to do with the instances of an agent who's acting for a principal who is outside of the jurisdiction. And that would touch and concern subclause 9, where it says subject to subsections 10 and 11, for the purposes of this section, an agent will be jointly and severally liable with the principal if he acts on behalf of a person who is not resident in Jamaica. And that was the subject of quite a bit of comment from stakeholders. I do not believe the views of the technical team were such that we felt it was appropriate for the provision to remain, but the stakeholders felt very strongly that in the case of, for example, shipping agents, all of their principals are out of the jurisdiction and unlikely to be resident in Jamaica, and that this exposes them to liability. And they were of the view that they should enjoy a similar exemption as customs brokers are given at subclauses 10 and 11. I bring it to your attention, we had not, certainly between customs and the stakeholders, we were not able to come to an agreement in relation to the submissions that were made on this issue.
This is the last one about 10.
Yes, it touches and concerns subclauses 9 as well as 10, because 9 lays down a general principle that an agent who acts for a principal who is not resident in Jamaica, that agent is jointly and severally liable. And so what it would mean, of course, is that the agent would need to enter into appropriate contractual arrangements with the principal to deal with that liability. For example, by having an indemnity agreement, an indemnity clause put into the contract between the agent and the principal. So that is the general principle, but a special facilitation was inserted for customs brokers, whereby a customs broker would not automatically be liable unless certain things, certain circumstances occurred, right? So that was an issue of general concern. The customs brokers had also raised a concern at subclause 10 in that it was submitted that as currently phrased, the provision appears to put the burden on the customs brokers to establish that they did not aid and abet, that they took all steps to prevent the failure and so on. And so they had requested that the provision be reworded so that it doesn't appear to shift the burden to them to establish that they acted properly. Of course, having regard to the general principle, the technical team were not at all dissatisfied with the current phrasing.
Chairman, my comments there is that I think there are some important policy issues for consideration and some practical issues as well. The issue, for example, of the non-resident principal is particularly complex, but I think it has to begin with the contractual arrangements in the first place. And it's not unreasonable for the state to require that those contracting arrangements have some basic elements in it. So for example, if someone is resident abroad, they must, the whole matter of jurisdiction and submitting to the jurisdiction in Jamaica, after all, they're doing business in Jamaica. that they should subject themselves to the courts in Jamaica in case there are disputes. I think those are basic arrangements. Indemnification provisions are normal in these kinds of arrangements. And so the joint and several liability question, I think are particularly concerning in instances where the principal may go bankrupt and the agent who is acting as an agent and not the principal may find under the joint and several liability, find himself exposed, not for doing anything outside of the contractual arrangement, but simply by virtue of the relationship they've had with the. So that's a ticklish one. I think we need to give some more consideration to it. I understand the state want a simplified arrangement where it holds somebody liable for monies owed to it. I think we have to look at the wider implication and the circumstances under which those could become real and present a threat, a real threat to Jamaican citizens who live here and is taking on a certain level of risk with these foreign arrangements. But it is weighty, and I don't think we should settle it on the fly. I think we should give some deeper consideration on it. But these are some weighty issues. The other one about
these are weighty. Sorry, go ahead, Member.
The other one about shifting the burden onto the agent if certain things are not done. I think it's less troubling to me. I think they need to, how you phrase it, I don't think it really matters. There are some basic evidentiary things that are required so that if you don't assist, you would know the person better. If you don't show some evidence of, one, that you're not complicit, and two, that you've made good faith effort to assist in doing so. Then I think it's not unreasonable for you to make some efforts. Now, if you want to talk about how it's phrased and if it shifts burdens of proof, I think we can look at it. But basically, the state is saying you entered into arrangements and it want to assure itself that you will not use the fact of the agency, which is after all a regulated activity, that you've not used your license and your arrangement to suborn certain activities. So I think that's not unreasonable having regard to the requirement to safeguard the public funds. But again, I mean, that's a more technical point. The first one is weighty. I think it's a weighty policy matter that should be given some serious consideration. The other one really is a technical point about evidentiary requirement, but it is not illegitimate, and I think the issues there, the state's concern is founded on evidence and experience. So we have to find a way just to clean that up. But the basic fact that you cannot use your office to suborn or to facilitate certain conduct, I think is supportable.
Thank you for that contribution, Member Hilton. As quite a valuable contribution, and I agree with you that these are some weighty issues.
When the committee meets again, we should come back to those. We should
Yeah.
want to-
Yeah,
Right.
yeah,
So may I?
please go ahead.
In respect of the treatment of agents, I think we appreciate the concerns. This is under clause 270 now.
Mhm.
Right. And I think the policy intent of the joint and several liability is clear. I don't consider it unreasonable for an invitation to reconsider whether there is any other way that the goals can be achieved without putting an innocent third party, innocent, I put in quote, but someone who has not colluded in any way or as a result or does not contribute in any way to a principal not honoring their obligations and liability to the state. It is indeed onerous. And the aim is to ensure that at all times, persons who transact with the revenue, here the custom, that the liabilities are clearly established. But you could note it to be recircled and to see whether it's kept in its current form or modified. But the goals are clearly clear and are unambiguous, that those who are transacting in circumstances where monies are to be paid, and those monies are important revenue for the public purse, that those obligations have to be met. When you look at the entire scheme of the law, the system is being simplified, it's being clarified and made transparent, and that's why rules are, many things are going to be done subject to the rules. Those rules are going to be in writing. You're taking out the asymmetry of information, so persons know upfront what it is that they are responsible for, how they are going to be assessed, how their liability or any suspicion of breach is going to be treated with. They're given fair opportunities to make good, and that's why you have the escalating scheme of the informal notice, the formal notice, the administrative penalty before you get in the realm of being charged with anything. How your records are kept, what is used against you in terms of your history of compliance. Because again, the scheme of the law is to take into account your history of dealing with the customs, and to ensure that if you have a history of dealing compliantly and well, then in the event of an exceptional circumstances is not held against you, and also that generally the ease with which you transact is enhanced given your history. So I think any reconsideration.
Hello?
Not
Yes.
hearing me? Not hearing?
Hey,
No,
Or
go
is it
ahead,
that
go ahead,
someone-
AG.
Oh, I see. No,
Yeah.
I was hearing someone else. So I'm saying, Chairman, the good thing is that the scheme of the
No, I'm not
law
aware.
and the different parts of it are very clear. So any matter that is to be reconsidered can be reconsidered in the fuller context of the part
Okay.
and the entire act. Because a lot of thought and clarity is
Yes, I was
behind
just-
each
okay.
of the provisions.
Fine, 9. Okay. Okay, all right. Good.
Understood.
Yeah, I just add, I think the risk base, the framework and the introduction of the risk base assessment is to be recognized and appreciated, and everyone involved in the system and who benefits from that, I think needs to appreciate the shifts, the important shifts, and the changes that are being made that are balanced in favor of transparent rules. I think it's, and people knowing in advance what the risks are to themselves, and really an acceptance of some level of reasonable risk must be part of the professionalization of those who treat with the customs authority.
I think Chairman, through you, in addition to what Member Hilton has said, what is clear as we go through the review of the bill is that the government is almost in an unprecedented way bringing order and standardization to an area where practically every Jamaican interacts with, an area of government. You know, the best of the informal practices are being codified. Those that have not worked are being discarded. So, you know, it's a law that I believe is really moving in the right direction. It has gestated for a long, long time, but it's not one of those where the long gestation did not result in improvement and enhancement and clarity of what is provided for. And the goal is to ensure fairness and transparency and symmetry, you know, on both sides for those who interact. So.
Yes, agreed. And these are, look, the policy intent is clear and the alignment is clear. It's just because, you know, the stakeholder comments have been raised why we're duty bound to consider them. But it doesn't mean that we don't pursue the policy intent, right? So Member Hilton used the word weighty. I think it's an accurate word. But it's also a weighty responsibility to have a customs agency responsible for facilitating ease of cross-border activity and also for revenue collection. And we have to ensure that the provisions that we have are in keeping with international best practices, and those who by their business or profession need to engage, need to, you know, to step up to what international best practices demand. Having said that, we will defer on the matter and have the chance to review it along with the other items that we will come to. And I imagine how we'll do that, we'll put them all on the table because some of them are, you know, intertwined. And we'll have the opportunity to once again revisit these issues and make a final determination. But thank you, AG. Thank you, Member Hilton, for those contributions. May we continue from 270, where we left off? Were we at A?
271.
271, yeah, okay.
Clause 271, exclusion of liability. The government shall not be held liable for any damage, loss, or expense incurred by any person arising from any action or decision taken in good faith in the exercise of any power, duty, or function of the government under this act or any other customs law. Clause 272, agreements. The commissioner may conclude agreements with persons or with ministries, departments, public bodies, as defined by the Public Bodies Management and Accountability Act, or executive agencies, as defined by the Executive Agencies Act of Government for the purpose of A, improving the ability of the respective parties to execute their duties, B, enhancing the level of cooperation between the respective parties, C, securing and expediting the clearance and release of goods, D, enhancing the security of goods, persons, or places that are subject to this act, or E, for any other purpose in connection with this act or any other customs law. Clause 273, payment of rewards. The commissioner may, with the approval of the minister, pay a reward to a person who provides information to the commissioner about an offense against any customs law or who assists in the recovery of any monetary penalty payable to the commissioner under any customs law. Clause 274, discretionary power in special circumstances. The Commissioner may permit the clearance, unloading, removal, or loading of goods, and the reporting and customs processing of vessels and aircraft in such form and manner as the Commissioner may direct to meet the exigencies in any case to which the customs laws may not be conveniently applicable. Clause 275, powers of officers. Subclause 1. For the purpose of enforcing the customs laws, a proper officer shall have the same powers, authorities, and privileges as a constable in respect of the powers of A. Entry and search of premises and other places and means of transport. B. Seizure and detention of items and evidence. C. Search, detention, and arrest of persons. D. Calling on and questioning persons. E. The inspection of goods and documents. And F. The investigation of offenses under this Act or any other customs laws in accordance with Part 13. 2. A person who obstructs an officer who is performing an enforcement function under Part 13 or fails to comply with a lawful request of the officer made in the performance of any such function commits an offense. Clause 276, acts on behalf of Commissioner. Subclause 1. Any of the duties imposed on the Commissioner by this Act or any other enactment may be performed either in place of or concurrently with the Commissioner by any officer so authorized by the Commissioner, subject to such conditions, if any, as the Commissioner thinks fit. 2. Subject to subsection 9, the Commissioner may, pursuant to an agreement made under Section 272, delegate in accordance with subsection 3 any of the Commissioner's powers under this Act to such individual, not being an officer, Ministry of Government, public body as defined by the Public Bodies Management and Accountability Act, or executive agency as defined by the Executive Agencies Act, as the Minister considers suitably qualified for the purpose. 3. A delegation under subsection 2 shall A. be in writing, B. specify the entity to whom the delegation is made, C. specify the functions delegated, and D. state the period of the delegation being a period not exceeding 3 years. And notice of the delegation and any suspension or revocation thereof shall be published in the Gazette and by such other means as the Commissioner considers appropriate to bring the matter to the attention of the public. 4. A delegation under subsection 2 may be renewed for successive periods. 5. The Commissioner may suspend or revoke a delegation under subsection 2 in accordance with the terms of the agreement made under Section 272 in respect of the delegation. 6. Notwithstanding subsection 5, the Commissioner may revoke a delegation, A. on the ground of any neglect of duty or misconduct of the delegate, B. at the written request of the delegate, or C. where the delegate is incapacitated due to illness or any other cause such that the delegate is unlikely to be able to carry out the functions delegated. 7. Where delegation is suspended or revoked under this section, the delegate shall surrender to the Commissioner all documents and other items received in connection with the delegation. 8. Every person employed in a duty or service relating to a customs matter, A. by the order or with the express concurrence of the Commissioner, or B. pursuant to a power of delegation under this section, is deemed in respect of that duty or service to be an officer. 9. Nothing in this section shall be construed as entitling the Commissioner to delegate the power to make rules under Section 261 or any other provision of this Act. 10. Every act required by law to be done at a particular place within a customs controlled area, if done within that customs controlled area at any place specified by the Commissioner for such purpose, is deemed to be done at the particular place so required by law. Clause 277, functions and duties of officers. Subclause 1, an officer may exercise the powers and shall perform the duties A, assigned to officers generally or to that officer specifically, or B, delegated to officers generally or to that officer specifically under this Act or any other law. 2, the Commissioner shall issue an identification card in such form as may be prescribed by rules to each officer. 3, an officer purporting to any person to exercise any power under this Act shall, on the request by that person, produce the identification card issued to that officer under subsection 2 for inspection. 4, a person who ceases to be an officer shall return the identification card issued to that person under subsection 2 to the Commissioner. Clause 278, delegation by Minister. Unless otherwise expressly provided, the Minister may, by instrument in writing, delegate any of the Minister's functions under this Act, other than the power to make regulations, to the Commissioner. Clause 279, confidentiality. Subclause 1. Subject to subsection 2, A, every person having an official duty under or being employed in the administration of this Act or coming into possession of any information by virtue of an authorization or agreement referred to in subsection 2 shall regard and deal with as confidential all documents and other information in respect of matters under this Act. And B, no person referred to in paragraph A who has possession or control over any documents or other information in respect of any matter under this Act shall disclose the document or anything therein to any person, and a person who contravenes this section commits an offense. 2, nothing in this section shall prevent the disclosure of a document or other information, A, by the Commissioner or any person so authorized by the Commissioner for the purposes of this Act, B, by the Commissioner or a person authorized by the Commissioner to any department of government, public body, as defined by Section 2 of the Public Bodies Management and Accountability Act, or executive agency as defined by Section 2 of the Executive Agencies Act, for the purpose of the performance of a function under any law. C, by the Commissioner pursuant to a requirement under any other law or any treaty, international agreement, or arrangement to which Jamaica is a party. D, by the Commissioner to any person pursuant to an agreement entered into between the Commissioner and that person for the purpose of assisting the Commissioner in carrying out any function under this Act. E, by any person in accordance with an authorization for such disclosure given by the Commissioner pursuant to an agreement referred to in paragraph D, or F, with the consent of the person who provided the document, if the disclosure with that consent is not contrary to any other law or to any duty of confidentiality owed by the Commissioner to any other individual.
Chairman?
Yes, go ahead.
In respect to this matter of disclosure, it is normal that if a person acting on behalf of the Commissioner comes into certain information of a sensitive nature, which required non-disclosure, that the fact of this person no longer serving in that capacity, and particularly if that person has been has been removed from the service for conduct or anything else unbecoming, then I believe that the requirement that non-disclosure follows the person, I think should be looked at very seriously. That if by virtue of no longer being in the service, that they can that the obligation not to disclose certain information, that they can then persist in that or engage in that sort of activity. I think we need to look at how we address what I believe is a
So what would you suggest?
Well, I think that the person that obligation should follow the person at least for constrained probably for a period of time after they leave the service, and not be the mere fact that they're, especially if they're asked to leave the service for conduct, that that person could tomorrow morning leave the service and then disclose or sell or any other, because that's not somebody who won't be served. The information will be safe unless he's obligated to continue. An obligation is imposed not to disclose that information. So I think at least for a period of time after having left the service, under those circumstances, either by retirement or being removed from the service, that we consider that obligation runs with him for a period of time. That's my proposal.
For 6 months?
6 months is probably too short. 6 months is probably too short. And we can look at, I mean, the non-disclosure agreement, this is really in the nature of a non-disclosure arrangement. And that's done in commercial settings all the time. In this instance, and this is true of government generally, not just in the customs. I mean, I think we need to look at, people come by very, very sensitive information by virtue of their position. And if they leave, I think so far, I don't see anything comprehensive that looks at that issue, where people can be damaged and information can damage person. And the fact that they no longer work for custom should not be a bar should not bar the obligation, and that person carrying that obligation with them not to disclose that information, and for a reasonable period of time. We can determine what's reasonable. But I think,
Is this the place to put that though?
no, I'm not saying this is the place. I'm saying it raises the question.
Right, understood. Someone is trying to come in?
Yes, Chairman, I was just suggesting that it might not be necessary to specify a time period at all, because usually these types of confidentiality provisions, they are in perpetuity. So it's absolute that once a person leaves the employment and so on, they are still barred from disclosing the information that was held confidential during the period of employment.
And that's generally true in the public service. Is that your point, CPC?
Yes.
Okay. Well, if that safeguard exists, then it may not be necessary. But
no, I'm not saying it exists. It would have to be provided for here. But what I'm saying is that we don't. It's not usually limited by a time period. Okay,
that's even better for me. But I think the point that I'm making, I think there's a gap there, and I think it needs to be filled. It's a matter of policy.
Right, it's a matter of policy, not necessarily here, but a matter of policy.
Yeah.
Understood, accepted. All right, let's continue.
Clause 280. Amendments to other enactments. Subclause 1. The Council of Legal Education Act is amended in A, the marginal note to section 5 by deleting the words "and transfer tax" and substituting therefore the words transfer tax and import duties and taxes. B, in section 5, by inserting the following as subsection 4. No import duty or tax shall be payable upon any article imported into Jamaica or taken out of bond in Jamaica by the Council of Legal Education and shown to the satisfaction of the Commissioner of Customs to be required for the use of the Council. 2, the General Consumption Tax Act is amended. A, in section 16, 1, by inserting next after subsection 2, the following as subsection 2A. 2A, where the prescribed goods are imported goods, the reference to the Commissioner shall be construed as a reference to the Commissioner of Customs. And 2, in subsection 5, by deleting the words Queens and substituting therefore the word government. B, in the first schedule, in item 1.
Just double check if Queens is to be governments, replaced by governments, or simply government. Just asking for check of context, because it's a possessive, the way it's written there. If it's Queens, should it be governments? Government apostrophe S? Just asking for a double check.
There, AG, can you repeat that, please?
Yes, it's correct because it refers to a reference to, it says a warehouse means a Queens or private warehouse. So it would be government warehouse.
Very well.
B, in the first schedule, in item 1 under the heading Group 11, motor vehicles. 1, by deleting the words US 35,000 CIF and substituting therefore the words the amount specified in item 1A. 2, in paragraph D, by A, inserting immediately before the words persons employed, the words the following. B, deleting the word or at the end of subparagraph 2, renumbering subparagraph 3 as subparagraph 4, and inserting the following as subparagraph 3 versus. C, inserting next after subparagraph 4 as renumbered the following subparagraphs. 5, guidance counselors. 6, deans of discipline. 3, in paragraph G, by inserting immediately before the word nurses, the word registered. 4, by deleting paragraph H and inserting next after paragraph G, the following paragraphs. H, persons recruited overseas by the University of Technology for employment at that university. I, persons who, having held an overseas scholarship awarded by the government, 1, return to Jamaica on completion of the courses to which the scholarship relates, and 2, are employed to the government. 5, by deleting paragraphs P, Q, R, and S, and substituting therefore the following. P, chairpersons of municipal corporations and mayors of city municipalities. Q, councillors of municipal corporations. R, lecturers who are members of the Mona campus chapter of the University of the West Indies group of university teachers and who are eligible for commuted allowance or full upkeep allowance. S, lecturers employed to the University of Technology who are eligible for commuted allowance or full upkeep allowance. 6, by deleting paragraph W and substituting therefore the following. W. Officers who are employed to any of the following entities and are eligible for commuted allowance or full upkeep allowance. 4-H clubs, Architects Registration Board, Banana Board, Bath Fountain of St. Thomas, the Apostle, Caribbean Maritime University, Civil Aviation Authority, Consumer Affairs Commission, Council of Community Colleges of Jamaica, Council of Professions Supplementary to Medicine, Dental Council, Early Childhood Commission, Fair Trading Commission, Hazardous Substances Regulatory Authority, Institute of Jamaica, Institute of Sports, Integrity Commission, Island Traffic Authority, Jamaica Agricultural Society, Jamaica Anti-Dumping Commission, Jamaica Council for Persons with Disability, Jamaica Cultural Development Commission, Jamaica Dairy Development Board, Jamaica Intellectual Property Office, Jamaica International Financial Services Authority, Jamaica Library Services, Jamaica National Heritage Trust, Jamaica Tourist Board, Jamaica Promotions Corporation, Legal Aid Council, Maritime Authority of Jamaica, Medical Council, Milk River Hotel and Spa, National Commission of Science and Technology, National Council on Education, National Library of Jamaica, National Parenting Support Commission, National Solid Waste Management Authority, Northeast Regional Health Authority, Nursing Council, Office of Disaster Preparedness and Emergency Management, Pharmacy Council, Planning Institute of Jamaica, Police Civilian Oversight Authority, Private Security Regulation Authority, Professional Engineers Registration Board, Public Broadcasting Corporation of Jamaica, Quarantine Authority, Rural Agricultural Development Authority, Scientific Research Council, Southeast Regional Health Authority, Southern Regional Health Authority, Special Economic Zones Authority, Statistical Institute of Jamaica, Tax Administration Jamaica, Tourism Enhancement Fund, University Council of Jamaica, University Hospital of the West Indies, University of Technology, Water Resources Authority, Western Regional Health Authority, and any statutory body that the minister may, by order published in the Gazette, amend this paragraph to include. 7. In paragraph 10, by inserting next after the words regional supervisors, the words and who are eligible for commuted allowance or full upkeep allowance. C. In the first schedule, under the heading Group 11, Motor Vehicles, by inserting next after item 1, the following item. 1A, the specified amount for the purposes of item 1 is, in the case of A, the Prime Minister or a former Prime Minister, US 60,000 CIF. B, the Leader of the Opposition, the President of the Senate, the Speaker of the House of Representatives, a Cabinet Minister or the Attorney General, US 55,000 CIF. C, a Member of Parliament other than a member specified in paragraph A or B, US 50,000 CIF. And D, any other person referred to in item 1, US 45,000 CIF. 3. The Proceeds of Crime Act is amended in the second schedule thereto by renumbering paragraphs 19 as paragraph 20 and inserting the following as paragraph 19. An offense under section 40, subsection 5 of the Customs Act. Clause 2.
Sorry, Chairman.
Yes, PBC.
Just to point out that that renumbering now has to be adjusted because there were some amendments to the Proceeds of Crime Act after this bill was tabled. So the correct renumber would be to renumber paragraph 21 as paragraph 22 and insert the following as paragraph 21.
Okay, got that?
Clause 281, repeal of Customs Act. The Customs Act 1941 is hereby repealed.
Okay, thank you, Ms. Corbett. We now have, yes, go ahead.
So just a note, in the list that was read out earlier, that I observed that this agency, the Jamaica Customs Agency, was not included in the list. And so I need for that to be done. And I ask that Ms. Edwards and team look at the reason as to why the Jamaica Customs Agency was not included in this list. Right?
Okay, what I'd say, no, before we go with what I'd say on that, Commissioner, is that's a matter of policy that we're not, we don't change without a cabinet submission and agreement. What is here is a result of historical factors that we'd have to research and find. There are a number of entities that are not here. Customs is only one. But the direction in which we're moving with the compensation reform, would be a direction in which, these kind of anomalies across entities and so on would be substantially reduced, if not eliminated. But the place to do that is not here. That's a separate matter altogether.
Noted, Minister.
Yeah. With respect to the schedules, clearly we can't read the schedules word for word, one, and two, most of the schedules, refer to matters of policy, i.e. Duty rates for different items and characterization of items according to, I guess, World Customs Organization and so forth. Would we just need to go through page by page, do a page by page of it? Starting today and then continuing whenever we meet again. Is that what the committee would, it's quite tedious, but is that what the committee would suggest, or do we take it on block? These were lifted for the most part from the existing Customs Act. Is that the case? CPC and the Commissioner, Hazel?
Chairman, for the most part, yes. So for example, with the first schedule, the bulk of it constitutes the tariff, and that would have been lifted. It is not possible for Jamaica to make unilateral amendments to it, but we do wish to bring to the committee's attention the fact that a new tariff is being developed and is likely to be and agreed at CARICOM and is likely to be on stream for 2022. So we will, if all things proceed as expected, we will be replacing a significant portion of the tariff shortly. There are, though, other aspects of, for example, the first schedule that were the subject of policy decisions that were taken, and so there are some changes made. For example, under the portions that bear the subheading Section 22, total or partial exemptions, there were some adjustments made, and we'll be making a recommendation for example, a definition to be inserted in one of the provisions to provide further clarity consequent on further discussions and comments from stakeholders. There are also certain parts of the first schedule where new matters were introduced. And in particular, I am referring, so part 4 remains, I believe, substantially unchanged, but part 5, there are some new additions to be made, and new matters were inserted there, and there's some further new matters to be
When
inserted.
say new matters,
In terms of just listing, so those are matters that would have been agreed before. So when one looks at the existing provisions,
they may not be in one
schedule,
place. What you have done is to
Yes.
consolidate, you mean?
there's some consolidation, Minister, but there would have also been, in terms of comparing what now exists
Mhm.
versus what is in this document, there would be 1 or 2 changes. And for example, Minister, we have at part 8, goods imported from meetings, incentives, conventions, or expositions. That would not be in the current schedule in terms of what is now attached to the
Right,
1941
but
Act.
there's no change in policy.
No, Minister, not overarching in terms of giving benefits, not in that
Exactly.
sense, but
Right. It's just for whatever reason, it's been included in one compendium, whereas before it might be in different parts or different. But here's what we can do. You know, what we can do is if there aren't too numerous as we go through, you can highlight
the changes.
highlight whatever the changes are.
yes, Minister, of course. But to be clear, Minister, for example, part 8, that when this bill was being developed, it was agreed that it was a policy decision taken at that time by the government to introduce.
I remember
this
it.
benefit.
Yes.
Right.
Yes, I remember it. So it's
Yes.
not a part of the, you know, you're including it here for the first time, but it's not that this committee is coming up with any new policy as regards
No,
the schedule. Right.
No, this policy had been agreed by cabinet before.
Right.
And so
So
we're just-
unlike what we have just finished with those 280 clauses where this committee, you know, would have made amendments here or there, this is the subject of policy. And,
Yes.
you know, if there are grammatical or sort of editorial kind of changes, fine, but, you know, no changes of substance.
No.
Right. So, Member Hilton,
Yes.
what do you think? We just call the page numbers and we go through them? Is there any, it's how many, 600 pages? Is that what we do, or we do page by, I mean, Parliament, we take it page by, for, the budget, we do chapters and we do, now, I don't think it's practical to sit here and call out 600 page numbers for things
Minister,
that we're not going to change. Yes.
Suggesting that maybe we could contemplate them in sections, and then the team could highlight where there are any major changes to be taken note of.
I
Because
think that's a,
page by page might be a little less than efficient.
yeah, I agree with you. Thank you for the suggestion. We could just do it in parts and you indicate the changes, customs. Okay? So let's go. The general note,
No changes on the general note, Chairman.
all right, abbreviations and symbols,
No changes.
all right, list of titles and section chapters,
No changes were made there.
part 1, schedule of rates.
No changes were made there, Minister, except to make one observation in relation to chapter 8. Chapter 8.
tell us the page number when you're,
Right, so the page number for me, so that will be starting at page 42
this is in the,
and 12.
chat.
In,
I'm not sure what document you are.
Where I'm using the, oh, right, where I'm using the.
it will
this.
be page 258 if you're using this one.
All right, 258, right. Okay, so where are we schedule of rates? And you're saying chapter 8 on page 258.
And
the big
turning
book.
over,
Mhm.
right, and turning over to tariff heading 0804.
Right,
04.300X. Okay, Minister. I think I am. All right, it seems to be an error with my note there. I had that there was a letter missing, but it seems to be fine.
all right, so schedule of rates, which is the bulk of the book. Okay, the schedule of rates goes from, the 200 all the way to page 769. It's over 500, nearly 600 pages of rates. So we take that as no changes, so we accept that, the committee accepts that. And we're moving now to part 2, which begins on page 769 in this book. Part 2, are there any changes in part 2? List of commodities ineligible for conditional duty exemptions. So we're on part 2, list of commodities ineligible for duty exemption. And this has to do with the list of ineligibility with CARICOM.
Yeah, I should think so.
Yeah.
But
That's a list that we don't have the, don't have the power to alter. Part 3 is a list of goods in relation to which, and that is on page 797, a list of goods in relation to which those subject to a 50% rate of duty immediately before the first day of April 1994 are excluded from an exemption under the schedule.
Chairman?
Yes.
For you.
If you just allow me to ask, Mr. there was a question. There was an issue in terms of the heading for the fourth schedule, the list of ineligible. That should have been corrected in terms of splitting it in part 1 and part 2.
Okay, so indeed, I had forwarded same to the CPC. I hadn't mentioned it yet because it had not awaiting her review and the finalization of it. But it would not involve, Chairman, necessarily changing content, but just reordering and inserting appropriate subheadings into the parts because it has an impact on how the benefit is granted, so that certain parts, so for example, one may have part 2, but part 2 may need to have a subpart A and a subpart B because the list of goods that would, for example, be under the subpart A are treated differently from the list of items that would be under the new subpart B. So we are suggesting the insertion of some subheadings throughout the first schedule to assist with better clarity.
So is that already here or?
So for example, Minister, where we are at now under section 22 dealing with total or partial exemptions,
Yes.
the first list of items here, that's now 1 to 39, we would recommend that become a subpart A.
Sorry, we're still on that list of ineligibles. I'm
Well,
confused.
no, Minister, I believe, well, Mr. Lowe's comment was in relation to what is now part 2 or what is now section 22. Total or
Right,
partial
part 2,
exemption.
yes, part 2, list of commodities
Part two,
ineligible for
yes.
conditional duty exemptions.
Right. So at part 2,
Uh-huh.
we would recommend that the first portion, starting from tariff heading 0702, tomatoes fresh or chilled, that until ending with tariff heading number EX9607, slide fasteners.
EX what?
EX9607. So if we go down to 9607, that would suggest that become a subpart A.
So part 2A.
So it would be subpart A of part 2.
Subpart A of part 2. And what's your reasoning?
Because the list of items that goes down to EX9607, that is treated differently. So that is one list and it's referencing certain other provisions, and the duty and tax consequences for that list is different.
As a practical matter.
And then we would have another subpart B that would start with the list of commodities that begins with tariff heading 0210, meat and edible meat, offal salted in brine, dried or smoked. That would start subpart B and go down to the commodity bearing tariff heading number 9615.90.10 hairpins.
Chairman.
Yes.
Chairman, this is, I mean, my understanding, these may seem very arcane, but businesses will either survive or succeed based upon some of these little lines and these tariff headings and
yeah, no, I think
I don't know if I don't know if we're equipped now to really do justice to these whole set of schedules. I think we need to understand, one, what is being asked of us as members of the committee, and what I mean, because we can't make changes on the fly.
So member Hilton, we are acting on the representation that what is here is what exists today. Okay, that's the representation that we are being given from customs. And I think it's a representation that we can take. The suggestion being made here with respect to this element of part 2 is just to, you have a list of tariff codes, 1 to A to Z, and then 1 to 100. And what they're just suggesting is that we call A to Z, just a part 2A, and we call 1 to 100 part 2B. And that's not something on which, that's something that's acceptable. It's not changing any tariff code or any duty rates or anything that's likely to affect the experience of a business. It's just for administrative purposes, having them in, rather than one continuous block, A to Z, 1 to 100, just to demarcate them as part 2A and part 2B. That's the only change that they're suggesting, and they're representing that everything else remains the same.
In fact, Chairman, as it is now, there are subheadings there, so they are treated differently. So the only distinction is in the the wording of the label, but the actual effect of the provision will be unaltered.
Yes, there are subheadings there already. I can see them.
Right. So they're
02.10 is a
unaltered.
subheading. But this is for user ease, Member Hilton. That's what it really is. You know, so it's just making it easier to. I mean, it's 600 pages of, well, I mean the previous part, but this part is quite long as well. And they're just saying it's segmented, but you'd have to look closely to see that it's segmented. If you look at page 779, what's the heading number 0.2.1, you would think it's a tariff code, but it's not, it's really a heading. So they're saying to make the fact that you're in a different category clear, just call it part 2B. And I think it's fully in keeping with making this thing reader friendly.
Yeah, okay.
So yeah, we're okay with that. All right, can we move to part 3? Are there any changes in part 3?
That I recall, Minister, no changes at part 3.
Okay. Are there any changes in part 4? That's on page 801.
At part 4, the main change there, Minister, is at item 5. She gets there.
Part 4, item 5.
Item 5.
And there's no item. Which page is that?
I'm sorry.
Item
Looking at, so at part 4, productive inputs relief for the production of primary products and the manufacture of goods.
Yes.
Under the second item, manufacture of goods.
Yes.
There's a listing there from 1 to 6.
Yes.
And adjustments were made at 5 and 6, I believe.
No, but what adjustments?
Well, 5 was an insertion, so 5 would not be in the, we don't have a provision currently that deals with it. And this is to deal with incentives being granted to persons who are producing energy from renewable sources.
Right. So that was a policy that came into place.
Yes.
But has not yet been updated in the existing. Correct?
Yes.
But right, it's not a.
But this had been approved.
Policy, right?
Yes, this was approved by cabinet.
But it's just not. You would not find this written in the existing collection of documents that this replaces.
That is correct, Chairman.
But you would find it in Parliament. I mean, not in Parliament. You'd find it in cabinet. It's
cabinet decision.
It's cabinet decision, right? Okay.
Yes, Chairman. Similarly, at 6, prefabricated buildings and parts thereof imported by the taxpayer, certified by the Minister responsible for agriculture to be an approved farming enterprise.
Got that.
Right.
Everybody with us on that? What we're doing is just saying that, yes.
Chairman and Ms. Edwards, for in part 4, both 1 and 2, and maybe 1 in particular, how does this relate to the issue with CARICOM? And because as you know, there's a soap issue right now, and the persons in DCP in Dominica is contending that raw material imported into Jamaica, even though we provide the production relief, and if it be consumed here in Jamaica, they have a particular issue with that.
Minister, this is not the forum for that.
Yes, indeed, and that's the subject.
It's not the forum for that at all.
Okay.
Yeah, we have.
Okay.
Yeah. So what we're doing, you may have joined, we're just going through the parts, and on the representation from the teams that what's in these schedules are identical to what exists in the multiple documents that make up our customs regime today. And where that is not the case, they're pointing them out. But in each case that they point out, it's not, the things that are here are not new from a policy perspective, even though they have not yet made their way into the collection of documents that are currently available. But these are policies that have been approved some time ago, and the opportunity has been taken to include them since we're doing a complete repeal and replacement. So 5 and 6 fall into that category.
Look, Minister, wouldn't it be more efficient if, since the technical persons are seized off those particular items, wouldn't it be? And so what we have is that there's a reproduction of the overall regime, right. And as you point out, there are but a few items.
We're nearly there. We're nearly there, member.
Okay.
We're nearly there. Don't get impatient.
No. I was trying to aid the process.
No, I hear you. But let's see. If I get stuck again, maybe I might have to come back to you. All right. Customs. Part 4, that's the only change. Part 5. That's productive input release for the tourism industry. I mean, it's fantastic to have all of this in one document. This is
Chairman,
humongously positive step. I don't know if you understand how much of an improvement to the business environment it will be that you can have in one place.
Agreed. I welcome that. I think it's a great thing. My only thing is how now in this review process, what is the efficiency? To have it in one book, I applaud the effort, yeah. and I believe that it is a great step. It's a great advancement forward. I'm just saying, in terms of a review process, how to make that.
Yes, it doesn't mean that we have arrived.
Right.
It's a substantial. Yes, AG.
I am joining to let persons who are listening and are watching with keen interest, and it's really just endorsing and echoing what you've said. The inclusion of the schedules in the Act in this way is unprecedented, but it is necessary because what existed or what currently exists and will no longer exist when the bill passes is the anomalous position of schedules to the Act existing in different places, because by law, the schedule is part of the Act. And for some reason, we've been operating not just in customs, in the realm of the custom law, with an anomaly, so that although it may appear tedious to go through, because indeed there are fine prints, it's really critical that we go through. The other thing is to ask your policy division and for you to give some guidance, just so we need to know the frequency with which any of the schedules would have to be amended so that we can make a provision for it without it becoming too difficult. We're just learning so many lessons from how we do things, particularly in the realm of tax and tax administration, and customs is a subset of that. So
yes. I just think we need to reproduce the book every year. I mean, there'll always be, the schedules are going to be amended, unfortunately. Right now we have a few that are under consideration.
So we have to also make sure that the provision in relation to the amendment of it provides for administrative ease without compromising the necessary oversight that Parliament must give to it. Just asking that. That's really the crux of my intervention on this matter, as I join in letting persons know the positive difference that it will make for all of our lives who transact with custom to have everything in one place.
Yes, and what it really does is to level the playing field, right? The large companies can, get their arm around this thing because you have the resources to do so. For a small business just starting out, to access it in one place and not, you don't have to rely on batteries of lawyers and professionals just to understand what the laws of your own country are. It's a major improvement for the business environment. But let's not get too excited until we finish the parts. And then we're going to come back, obviously, at the next meeting and future meetings to all the big issues that we had deferred. I see a hand up. I don't know who it is. M. Oh, it's Mad.
Good afternoon, Minister and members. There are some changes that we need to make. We have to go back to the list of ineligibles. We noted some typographical errors that we had not pointed out. Miss Edwards indicated in terms of the headings, but we have some typographical errors.
What I'm going to ask you to do, given where we are in the day,
yes,
is to write them up and bring them at the next meeting. What I want to do, let's just get to the parts, and at the next meeting, we will consider those changes that you have. Since they're typographical, just put them to paper, please.
Sorry, Chair, might I suggest that if there are just typographical errors, I'm already making editorial corrections. So we don't really need to go through typographical errors.
Thank you, CPC. Can you send them directly to the CPC, please? All right, focus now. Part 5, productive input relief to the tourism industry. Any changes that were made? This is the same as it is now.
Yes, Chairman, I wanted to just also indicate that I don't have the exact figures that we changed from, but where we get to just after table 2, paragraph 4 and 5, there were some adjustments to the CIF values of the vehicles.
To bring it in keeping with existing cabinet approved policy. Is that it? 4 and 5.
I think we lost her.
I am still here. No one is hearing me?
No.
Yeah, so you're confirming this. I'm just confirming this is what these changes in paragraphs 4 and 5.
In terms of this, I know that there were changes.
The CIF value bring it up,
values
are consistent with existing cabinet approved policy.
Yes.
Okay, that's all we need to establish. All right, then part 6. What were the changes, if any?
I don't recall there being any changes to part 6.
Okay, part 7.
I also don't recall any changes to part 7.
Right, and then part 8 is a recent cabinet approved policy. By recent, I mean it could have been a year ago or whatever. To recognize the meeting incentives and conventions and exposition space, the MICE space, as a legitimate sort of sector, and to provide the principle of productive relief being extended to them, in the sense that when you in the MICE sector, meetings, incentives, conventions, and expositions, you have to import goods for those conventions, little trinkets, souvenirs for the conference, little prizes, and it would, they're not being imported for consumption other than at that meeting, convention, or exposition or expose. And if we want to have meetings, conventions, and expose, it doesn't make any sense to have the person pay duty on all of the trinkets they're bringing in for their convention or for the exposition. And so this was recently approved some time ago. But what I hear you saying is that it's not printed in any sort of series of customs documents, and is taking this opportunity of the repeal and replacement to include it here. I hope I got that right.
Yes, Chairman, you did. Chairman, before we move on, I had omitted to mention 2 fairly important changes that exist under that part beginning section 22, total or partial exemptions, the list from 1 to 39.
Mhm.
And the one I wish to highlight, Minister, the first change is
What page?
it
Oh,
would
you don't have,
be,
you don't have it in my book.
Could you repeat the section, please, that you're referring to?
I am looking at the part that begins section 22, total or partial exemptions. Looking at the bound document, it would be pages. It will be starting at page 754. So starting with item 3. So Minister, I just wanted to indicate that we'll be proposing that a definition of personal effects be inserted in order to provide clarity in terms of the application of the provision, and the definition that we'll be proposing will be the definition from the revised Kyoto Convention.
All right, but okay, fine.
Yes, we have forwarded to CPC for her consideration, so we'll await her guidance on that issue. To also bring to your attention that a change had been made at item 4, dealing with household effects and tools of trade. Paragraph 5, dealing with the foreign service officer. That was new, so you would not see that in the current provisions in terms of the time period there. Foreign service officers who have been assigned overseas for 3 or more years.
Okay.
So that would not be, as well as the provisions dealing with returning residents at D. So that is 5D, going down to, so that would be page 758. Yes, so we have always had a provisions dealing with returning residents, but there is a change here in that in the past, the returning resident would only be able to, or a person could benefit as a returning resident only once in their lifetime. But there has been an adjustment here so that a person who has been overseas for a minimum of 3 consecutive years and who returns to Jamaica with the intention
this is a policy change that was made.
That was a policy change.
Sometime recently to recognize the mobility of today's world, unlike generations ago or decades ago, where you're more likely to have a job for your entire life. Recognize the mobility of people today. You can be a returning resident more than once, legitimately, due to jobs and assignments that you take up. So this policy change was made some time ago, but it's been included now in the single compendium that we can have in one place, all the policies relating to customs. Thank you for pointing that out. All right, we're nearly at, it's 4:54. Only have 5 minutes left. And I think we were on the schedule 2. The second schedule rather, on 819.
Right, I believe we introduced a definition of spouse. That is the
right. So again, we're using the same, yes, spouses on page 820. We're using the same principle here that you're just pointing out the changes vis-a-vis the existing. And again, yes, this is a policy change that was made recently. You want to go through it?
Right, so this essentially just provides that when we're talking about a spouse, we're not just talking about married people, we're recognizing persons who cohabit together, a single man and a single woman who cohabit together for not less than 5 years.
Right, single as defined by law, legally.
Yes.
Meaning, single meaning not
And
married.
includes, yes, and it includes, well, single is also defined as including. For the purposes of this definition, it includes a widow or a widower.
Right.
Right, so essentially just an unmarried person.
Fair enough.
Yes.
Otherwise, the second schedule is the same as what exists.
Yes, Minister. Just
Right.
to note that coming out of the discussions that we had with the Revenue Appeals Division in terms of implementing Decision 6.1 of the World Trade Organization Valuation Committee, where you recall that the RAD had recommended that we insert express provisions to allow us to depart from the transaction value. And so we will introduce that as new language in the second schedule.
Okay.
What page of the bill we are considering, Chairman? What page are we on?
We're on the second schedule, which begins on page 819 and ends on page 834. Which is this identical to what exists today, with the exception of the definition of spouses, which has changed. And we are going to make another change that we discussed at one of our first meetings when the Revenue Appeals Division made a suggestion that was in keeping with international guidelines and regulations. How do you want to handle the third schedule, which is offenses?
That is entirely new, and the third and fourth schedules are entirely new. So I do not know.
All right, I don't necessarily want to push. I don't want to push for those today necessarily. Those we can have members look on between now and the next meeting.
Mr. Chairman, might I ask a question, please?
Sure.
Good afternoon. Good afternoon to everyone present as well. Just the definition of spouse just triggered a memory for me, and I thought I would just ask at this point. In relation to our CARICOM engagement, the protocol for contingent rights has two issues outstanding in respect of Jamaica, one being the recognition of spouses, and how it is that customs would recognize or spouses which fall within this informal category, quote unquote informal category, how they would be recognized at the port as spouses, and also the matter of tools of trade and how those would move between CARICOM countries. On the spousal issue, there was an immigration issue, which I know the AG's Chambers is working on in terms of how a non-Jamaican spouse who is not CARICOM, a CARICOM national, would be treated differently as opposed to a CARICOM spouse, as opposed to the spouse of a Jamaican, which is separate from this. But from a customs perspective, in terms of recognizing a spouse, you can't produce a marriage certificate. Has a practical solution been found by customs for the recognition of spouses at a port of entry, A, and B, in respect of tools of trade, which had many customs-related concerns, and the movement of CARICOM tools of trade, CARICOM national tools of trade versus others. Is this something which is being considered as we go through these matters, or is this something that is still being looked at for subsequent treatment?
On the matter of spouse, let me first turn over to customs. Any response from you, Hazel?
Thank you, Chairman. I'm trying to recall and trying to locate the document exactly in terms of the customs, the immigration and customs form that is signed and that persons need to complete to see whether or not it uses the term spouse. I don't recall. So I wanted to look at that before I responded. Other than this definition of spouse, which is for the purposes of the second schedule, right, which has to do with the relationships that exist between persons for the purposes of valuation of goods. Outside of this context, we don't have a general definition of spouse in the Customs Act.
If I may, immigration matter is an entirely different thing.
Entirely different and not a part of this discussion. The issue is the customs aspect as well.
Yeah. The custom, I think the way in which spouse arises in this document is going to be, as you said, as Hazel was beginning to say, and I interrupted, please continue, in relation to valuation of goods. But even so, how would you determine practically that this definition has been met?
But if I may, for customs purposes though, other than the question of persons who are traveling together or not, because each individual, if you are in possession of a particular good, it's not a case where you do declarations as a couple. You would be doing it as an individual. So I'm not sure if it's from the perspective of just the goods declaration perspective. I'm not sure that the relationship of one individual as a spouse of another would be so important for customs. I think each individual would need to take responsibility, would need to indicate these are the items that I have in my possession that I am declaring to customs and that I am taking responsibility for.
Chairman, my understanding, and I'll have to go shortly because I have another meeting, but my understanding, the Minister of Foreign Affairs in her intervention, I got from her that there are some larger issues around contingent rights that are CARICOM issues, and how people and their goods move where certain rights are attributed to those persons. So I don't think it's a narrowly declaration matter. I think it's a broader issue as to how we recognize in the customs, for customs purposes, those contingent rights that are part of the CARICOM treaty benefits. From my point, I just want to quickly say that I think we missed an issue, and I don't want us to forget it. When we addressed the matter in, I think, section 270 or in the 270s, the issue of the agent, I think the stakeholders had raised a preliminary issue as to whether the appointment and classification of and treatment of agents and training of agents were properly the rights to be.
We dealt with that, member, you remember?
No, I think we glossed at it.
We didn't gloss at it. We recalled the stakeholder comments on it, and we said that we are not focusing on agents per se, an individual agent, but categories of agents.
No, that's not the point I'm making. The point is a point that stakeholder raised about whether that should be the training and agents would not properly be left to the private sector rather than government. Now, you may have an answer to that. I just think that it was not ventilated or discussed. And since it's a matter that the stakeholders raised, I think the committee are properly to consider it and respond. And if they have
you'll recall that we have 270s on our list of our
I'm just
to come back.
I'm just flagging it. I'm just flagging that, and as part of that. So, with that, Chairman, unfortunately, I have to.
Yeah, I think we're running out of time for this meeting. I know everyone has been here long enough. We, on the matters raised by the Minister of Foreign Affairs, just have to defer on those until the next time.
May I just flag that Ms. Davis was working on it, Chandelaine Davis, I know she's aware of it, so if it could possibly just be looked at to ensure that we are treating with it holistically, if it is in fact, if it could in fact be addressed in this context.
If it can be, yes, if it doesn't require cabinet approval separately.
Yes, of course.
Yeah, so can you come back with a response on that first, Ms. Edwards? please?
Yes, we will look at it closely.
All right. And I'm going to ask members, we're going to, we stopped at the offenses, which is just the very last, very last section of this. Next time, I'll take it en bloc next time. If there are any comments on that section, I'd ask you to raise them.
Chairman, I wouldn't suggest that the offense section be taken on block. We really do have to look at them closely. But I promise you that once it's done, it will make life when we go back to report to the House easier.
Sure, okay, I'll take your recommendation. So we will start at the third schedule the next time. Yes.
Madge here. I'm sorry, but I have to take it back. I'm not sure if you had dealt with it, but because I fell off because I'm on my phone. But on page 599, there's something that I think we need to address in terms of item 4A1. It speaks to rental cars, and unlike the tour operators, we have not referenced that the benefit is for the sector. So I think that needs to be clarified.
All right,
there.
can you repeat that at the next meeting as well, please? If we haven't got it here, because you said a page number, I can't find it in my thing.
Okay, so there's another on page 600 also where the list of beef cuts that has been expanded. I'm not sure if we had dealt with the additional items that were added. So I will speak to that at the next meeting then, Minister.
Sure, that's another policy change that has been made. Is not yet, it's a cabinet approved policy maybe a couple of years ago, but it's not yet in documented form. And we're using the opportunity to put it in documented form.
Right.
All right, so we have some tidying up to do and some other matters to discuss before we turn our attention or return our attention to some of the bigger items that we have agreed to defer and that we'll have a substantive discussion on. What I'll ask Customs to do in the meantime is to extract all of those items and to prepare a separate matrix for those items, laying out the clauses that we have agreed to defer and laying out what the clauses that are the policy intent and what it's trying to achieve, what other views might be, and just put us in a position where we can have an efficient review of those items that we have promised ourselves we will return to.
Noted, Minister.
Okay. All right, so date and time of next meeting. We were originally scheduled to meet next week, but I have fortunately, the funeral of my CPO is next week, Thursday. And so I won't be able to be here for next Thursday, which I guess means that the next meeting will be after the recess.
Chairman, we're coming to the end of it. The time has been used very well and very productively. This is a huge bill. It's a lot of change monumentally. So I would say
the time is not.
I know you want to get it done, but the break is not a bad idea. I would just ask that in the interim, I can't recall if that's what you did because my sound went out. If you had said that we just get a list of what we have, a reminder of the matters that we're to return.
That's what I asked for. That's what I asked for.
Very well, and it'd be disseminated.
And during this break, which will be for the rest of July and August, we
take a look and come back.
Yes, and I would ask you, Kamisha, if you can. Let's discuss some dates that might be available in September and see if we can reserve them from now, and we'll obviously circulate so members are aware.
Yes, Chairman.
The date and time for the next meeting, we won't agree here. It will be by email. Okay. All right, any other business? Okay, if there's no other business, can we have a motion for adjournment, please?
So moved.
And seconded?
Seconded.
All right. Thank you, Senator Allen. Thank you, AG. All in favor, I should say aye.
Aye.
All right, thank you all very much. I think we've done. Thank you all very much. I know this is not an easy task to sit through.
So Chairman, what if a divide
complicated.
were called on the motion for adjournment? How would you treat it? And you
Repeat
get
that?
outvoted?
What
What
was
if
that?
if a divide were called on the motion for divide and you get outvoted?
That's why I said I want a proposer. I want a second. I at least have 2 votes plus minus 3. So I'm good. I count the numbers, AG. Count the numbers.
I know you're a numbers man. Yes.
All right. Thank you all very much. And see you when we resume in September.
Okay, good afternoon all.
Afternoon all. Bye-bye.
Afternoon.